deeply disturbed that the Senate is moving forward with this nomination. When it was announced that the FBI could investigate these serious and credible allegations, I had hoped that there would be a legitimate investigation. As the former Attorney General of California, I have tremendous, tremendous respect for the sworn law enforcement officers at the FBI. And this should have been a search for the truth. They should have been allowed to do their full job. But instead, the White House did not allow it. This was not a search for the truth. Instead, this was about politics and raw power to push through an unfit nominee. I am a former prosecutor. I have led investigations, and I have prosecuted all types of crime, particularly violent crimes, including specialization in sexual assault cases as a prosecutor. I have tried these cases in a courtroom. I have spent hours with assault victims. And I can tell you that when we look at what happened during the course of these days, these few days in reviewing and giving regard and respect to Dr. Ford, we have fallen short. We have fallen short. 63% of sexual assaults are not reported to the police in our country. Delayed reporting is normal. Mr. President, I will tell you that when I was personally prosecuting sexual assault cases, we would be in a courtroom. I would be there as the prosecutor, the accused attorney, a judge, and then a courtroom full of prospective jurors. And we would engage in a process called voir dire, where we would talk with prospective jurors, with our fellow citizens, to determine if they would be able to sit as a juror and without bias, listen to the case, and then make a determination about the facts and the law. I cannot tell you the number of times, colleagues, that a prospective juror would raise their hand and ask, could they quietly speak with me and the defense attorney and the judge in judges' chambers outside of the courtroom and outside of the site and the ability for anyone else in the courtroom to hear. And we would go into the judges' chambers. And I cannot tell you the number of people who would sit in a chair and with tears in their eyes tell us that they had been a victim of sexual assault and had never told anyone, not even their spouse. But because of what they had experienced, they knew they could not possibly sit in a courtroom and hear the testimony that they knew would come related to the charges that they knew the case was about. This is an issue that impacts so many Americans, most of whom don't report it and don't tell anyone. And usually when they do, it is because something precipitated the telling of their story that was beyond the time during which they endured the assault itself. Dr. Ford's experience in this regard is no different from the majority of sexual assault victims, and she should be believed. I know what it means to engage in an investigation and a search for the truth, having been a part of investigations to determine what has happened, and in particular, if a crime has occurred. Now, let's be clear about one thing. There's been a lot of conflation around here about the subject and the need for an investigation into Dr. Ford's allegations. Ours was not a search to determine whether a crime occurred. Ours was not a search to determine whether we had enough facts to prove beyond a reasonable doubt that a crime had occurred. No, ours was an investigation to figure out enough about what happened to determine if Brett Kavanaugh is fit to serve on the highest court in our land. Is he fit to be a jurist in the place where we have said justice in our country occurs? In the House, where we listen to evidence and truth and make determinations based on the veracity and the truthfulness of what has occurred. That is our role when it comes to Dr. Ford's allegations. And we fell short. We fell short. We did not do her justice. We did not do the American people justice. We were given 1 week to investigate. The Republicans said, you'll get 1 week. They threw out 1 week, an arbitrary amount of time. And in less than 1 week, we are presented with paltry documents. There was not, clearly, when the White House directed the FBI to do its work, it appears from everything I've seen, the FBI was not permitted to look at all of the allegations. That's clear to me. It is clear that the White House did not permit the FBI to request Mark Judge's Safeway employment records. It is clear from everything I've seen, the White House did not permit the FBI to investigate the dishonest testimony of Brett Kavanaugh or to examine and listen to the evidence that would have been provided by a list of over 24 witnesses that would have been at the very least able to corroborate or deny the allegations that were made. This was not a meaningful investigation into the allegations that are before us. And this, most importantly, was not a search for the truth. Media outlets have reported that there are more than 40 people with potential relevant information who are willing to share their information, but only 9 people were interviewed. This is a travesty. They did not interview the Georgetown Prep alumni or others from that era who contradict Kavanaugh's testimony. They did not interview Dr. Ford's husband or a number of her friends who she told of the assault before Kavanaugh's nomination. They did not interview the former FBI special agent who conducted Dr. Ford's polygraph. They did not interview Kavanaugh's roommate at Yale, who has contradicted Kavanaugh's testimony. They did not interview another one of Kavanaugh's neighbors in the dorm at Yale. They did not interview 3 of Kavanaugh's friends from Yale, who wrote in the Washington Post just last night, quote, Brett also belonged to a Yale senior secret society called Truth and Courage. We believe that Brett neither tells the former nor embodies the latter, end quote. They did not interview Dr. Ford at all. They did not interview Dr. Ford at all. Did not give her the ability to speak her truth during this so-called investigation. And they did not interview Judge Kavanaugh about these allegations. This was not a search for the truth. This was not an investigation. This was an abdication of responsibility and duty. And this on the heels of a process that began with hiding more than 90% of Judge Kavanaugh's record. We only received approximately 400,000 pages out of an estimated 6.9 million pages of documents. The Republicans have been saying, oh, you should be happy you received thousands of pages of documents, because they want us to treat crumbs on the table like it's a feast. These were crumbs on the table compared to the vast amount of information that is available to some about his background. This process has left the American people with more questions than answers. This has not been a search for the truth. The minimum standard for a Supreme Court nominee should be someone who we are confident will demonstrate impartiality, integrity, and truthfulness. But the nominee we are voting on has not demonstrated those qualities. Every American is entitled to the benefit of the doubt, but nobody is entitled to a seat on the United States Supreme Court. I yield to my colleague, Senator Murray.
Mr. President, I want to thank the senator from California for very clearly outlining for all of us to hear why this was not a search for truth on an issue that affects so many people in this country, the victims of sexual assault, who often, as she just described, do not talk about it, Do not speak about it. Do not ever tell anyone until there is a reason to, which is what Dr. Ford did. And while the senator from California is there, you said this was not a search for truth. When it comes to victims of sexual assault, and you've dealt with them time and time again as district attorney and attorney general in the state of California, what message does this send when they see the United States Senate?
Tell you that my great pain, and you and I have talked about it, we've all talked about it. Part of the pain of this process is a real concern that sexual assault victims and survivors may take away from this process, that their stories won't be heard or believed. Part of the pain that I'm taking away from this process is those that have a story to tell or might have been prepared to have the courage to report may decide, look what happened to Dr. Ford. It doesn't matter. No one will believe me. And why should I go through that? And so I have to say this, and you and I have discussed it, Senator Blumenthal, we've discussed it together. Part of what we must message, even if our Republican colleagues will not, is to all of the women and men out there who have experienced this. We will hear you, we will see you, we will respect you, we will give you dignity. Speak your truth. Do not be afraid. Do not let this system or any aspect of it bully you into silence. It is critical that we talk about this issue. I believe this is an issue right now that is where the issue of domestic violence was about 30 years ago. There was a perception about domestic violence that I hope we have gotten beyond, but there was a perception about domestic violence. Oh, you know, what happens in the king's castle is the king's business. That's private business. That's not our business. But then we evolved as a society and we realized, no, if she's walking around with a black eye or a busted lip, that's everybody's business. She deserves to be safe and we must stand up for her. I believe this is an inflection moment on the issue of sexual assault. And I hope and I pray that this is a moment where everyone will agree no one should silently suffer. Let's talk about this. Let's talk about the facts that every 98 seconds in the United States of America, someone is sexually assaulted. Let's talk about the fact that 63% of sexual assaults are not reported to the police. Let's talk about the fact that since Dr. Ford had the courage to speak out, one of the biggest national organizations that addresses sexual assault saw a 738% increase in the calls they received from survivors of these cases.
I think the senator from California, and I so agree. And this is one of my biggest fears about this moment. And let me talk about why that is true. I was just a mom at home in 1991. I was a state senator, but really not interested in what was happening here at all. My interest came because I watched the Clarence Thomas Hill hearings. And I watched how a woman shared a very difficult story with an all-male panel of the Judiciary Committee at the time. And she was disbelieved, she was swept aside, she was treated as if her voice wasn't important, and she was not believed. I was so angry as a woman because, like so many women in this country, I knew of so many people with experiences much like hers, who too at work at that time had been dismissed, not believed, were afraid to speak up. And I was angry. And I went to a gathering that night and I told some of my friends back in 1991, the night of the hearing, I'm gonna have to run for the US Senate because I need to be inside that to speak up for these women. That's what motivated me to run. I was not given one chance of winning that Senate race. Here I am today, 27 years later. Why? Because so many women and men who understood shared that experience and knew that voice needed to be here. That's what brought me here to the United States Senate. So let me talk about Dr. Ford because I listened to her like everyone else did. And I heard her voice and it rang so true to me. I watched her with tears in my eyes because she was honest, she was sincere, she was persuasive, she was credible. She had no reason to lie, none. In fact, I think we should remember she did not want to come forward initially. She was worried about the attacks that would come. She knew the history, as every one of us do, what happens to those courageous voices when they speak up, the invasion of privacy that they have. She knew what it would mean for her family. She only came forward when Judge Kavanaugh was on the very short list for the Supreme Court before he was ever sent to us. She came forward, she spoke out, but no one called her. And she didn't want to do it publicly. She didn't want to have this become what she was known for in her life. But she did. And if it wasn't for her, we would not be at this point. Now, Judge Kavanaugh was selected, and only then was Dr. Ford able to get her information to the people who would pay attention, and she insisted that it be kept confidential to none of our surprise. She didn't want a spectacle. She didn't want a show. Why did she do that? She felt it was her civic duty that we as United States senators who were giving essentially a job interview to a man who wanted a position on the highest court of the land, who would be judging people in front of him, we should know what his character was. Her story was compelling. She took a polygraph test. She did everything right. She had told people before. She presented her case credibly. And now it is extremely disconcerting to me, as someone who watched the Clarence Thomas Hill hearings and is sitting here, that I have heard people dismiss her, put her down, all the way up to the President of the United States. What message does that send across the country today to other women who are so bravely now telling their stories so it will not happen to anyone else? What does it say to them? What does it say to young girls in high school and college today? They're going to get away with it, so be quiet, because it'll only ruin your life, not theirs. What message does it say to young men? I've heard my colleagues say, well, it was high school, it was college. Really? Is that what we want young boys in high school today to think, that it's okay? Don't worry, whatever you do in high school does not count. Whatever you do in college doesn't count. I do not want my grandson to hear that message. I do not want my granddaughters to hear that message. I want my country to be better than that. Dr. Ford is a real person. She is not alone. And if any senator here in the United States Senate is listening, they will hear voices in their own states, from places they knew, from their own relatives, from friends they have not ever known about, bravely come forward because Dr. Ford did. This Senate, with the action that we are pursuing, could quash those voices forever. Now, to my friends out there and to everyone who has a story, do not be silent. That is not how we win this for the future. But know that we do believe you. The Senate has changed since then. I was proud of the Judiciary Committee members on our side, because unlike when I watched the Senate in 1991, there were women and men there who were listening, and they are today. But we have to, in this Senate, think about the consequence of this vote to so many people who are listening today and asking, do I say anything or do I let it happen? And I would just urge my colleagues to remember the lesson of 1991, where too many people felt, I can't speak out. We're changing, we're growing, we're speaking out. And it's so imperative that this Senate stand behind those women. We hear you, we believe you, we know that that happened to you, and you need to tell your story, and you need to have the courage, and we'll be behind you. But I would say to the senators who are joining me today, both who have been involved in these cases, that I am concerned that this message could be the wrong one for young men and women who are coming behind us. And we have to stand up for them. And I would yield to the senator from Connecticut.
Thank you, Mr. President. I'm really honored to join these two eloquent colleagues who have been a champion, each of them, for this cause, and as women speaking about the problem of sexual assault in our country, the epidemic of sexual assault that continues to be a scourge across our country. And most of my career in law enforcement, like my distinguished colleague from California, has been involved in making laws work for people and deterring exactly this kind of heinous lawbreaking. It is criminal. It's a crime. But it is one of the least reported crime because of the public shaming and character assassination and mocking and ridiculing that we've seen from men in power over just the last few days and weeks. So I want to say, as a man, speaking on the Senate floor, and greatly honored to do so, to other men in this country, those men in power who have mocked and ridiculed Dr. Blasey Ford cannot be our role model. Those men in power, they may be colleagues, they may be the President of the United States, who have belittled and demeaned and dismissed Dr. Blasey Ford and Deborah Ramirez and survivors across the country. They do not speak for us. I believe Dr. Blasey Ford. I believe Dr. Blasey Ford because she was credible and powerful as a witness before us. And what she remembered and what she so candidly said she couldn't remember. I believe Deborah Ramirez. I believe all of you who have written my office or called us, as you have done, many of you in other states, to my colleagues, who have recounted the horrors of your personal experience with sexual assault, who have come to me as I've been in airports or rallies or other public meetings and shared with me your horrific stories. I believed you. America believes you. And let me say to Dr. Blasey Ford's sons, you should be proud of your mom. You should be proud of your mom because she is a profile in courage. And to Mr. Ford, you should be proud of your wife. And to all the men in America, we need to believe survivors of sexual assault. We need to protect and respect them, not just in word, but in deed, so that they will come forward and tell us their stories, and so that we can conquer this scourge. We should be proud of the brave women who have brought us truth that cannot be denied, no matter how much character assassination and public shaming they have endured. We know their truth. And this issue of how America moves forward on sexual assault is bigger than this nomination. It will last beyond the vote tomorrow. It will be a defining question for each of us as men, as human beings. Now, Judge Kavanaugh, in facing these allegations, has also revealed something profoundly significant about himself. When he came to the committee after Dr. Blasey Ford, he revealed his true character. He pulled back the mask on the judge and revealed the man. And what we saw was someone filled with rage and spite, self-pitying and arrogant, deeply partisan and threatening. We can disagree on Judge Kavanaugh's views on jurisprudential issues and policy and law. We can disagree on issues relating to his out of the mainstream, far-right ideological position. But what cannot be denied is that picture of Judge Kavanaugh before our committee, which indicated profoundly a lack of temperament and trustworthiness. That picture led former Justice John Paul Stevens to revoke his endorsement and to say his performance was disqualifying. And what we saw, as they say, a picture's worth 1,000 words, was a man who refused to answer questions. He snapped at my colleagues. He spouted partisan conspiracy theories. That's the real Brett Kavanaugh. The Brett Kavanaugh who characterized Dr. Ford's serious and credible allegations as nothing more than, quote, a calculated and orchestrated political hit. He, in effect, depicted her as a puppet or pawn of senators or political figures, not people who came forward voluntarily in their own right and on their own initiative, as truly they did. He was the Brett Kavanaugh who alleged that it was all, quote, revenge on behalf of the Clintons. He's the Brett Kavanaugh who, as the Portland Press Herald characterized it, quote, ripped off the nonpartisan mask, end quote, and never looked back. And he's the Brett Kavanaugh who threatened us, saying, quote, what goes around comes around. In Brett Kavanaugh's own words, a judge must be someone who is, quote, even-handed, unbiased, impartial, courteous, yet firm, and dedicated to a process, not a result, end quote. His own words. That is not Brett Kavanaugh, the man. It will not be Brett Kavanaugh, the justice, if he is confirmed. Brett Kavanaugh revealed himself to be a partisan, an angry and bitter partisan, not an impartial jurist. He did so in prepared remarks, planned and premeditated, well calculated, written word for word and delivered word for word as he angrily turned the pages. And that is the message that for me resonates. Because I've argued cases in the Supreme Court. I've spent a career standing before judges. Some of their rulings I liked, some of them I disliked. Some of their conclusions I thought were maybe incorrect. But I knew that those men and women wanted to be impartial. When they put those robes on, as Brett Kavanaugh has done, they left party and partisan interests at the door. And now when I go to the United States Supreme Court, if Brett Kavanaugh is confirmed, there can be no trust or confidence that he will be that impartial jurist. It is and will be a stain, a cloud on the United States Supreme Court and all the Supreme Court has in the way of power is the trust and credibility and confidence of the American people, which will be diminished forever. So let me pose a question to my colleague from California, because she so well described the voir dire process, it's jury selection, where we make an effort to pick jurors who are impartial and nonpartisan. If Brett Kavanaugh came to a courtroom, Senator Harris, where you were trying a case as Attorney General, and he were in the panel in the jury pool to be picked for a juror, would you pick him as a juror? And after that appearance before our committee, would you allow him to sit on a case where you were litigating?
Senator Blumenthal, my response would be no. My response is no. And I'll tell you why. Because one of the most important qualities of a juror in our system of justice is that they have the ability to receive information without bias, without any interest in the outcome. And Judge Kavanaugh has made it very clear to the American public that he is biased, that he is receiving information and perceives it through the lens of a partisan and through the lens of the person he has been in his entire career, which is a partisan operative. And there were moments perhaps during his initial testimony where he may have distracted us from that part of his history, where he talked, in a calm voice about certain things. He certainly knows case law and talked about it. But when the issues are hot, when it became about fundamental issues, the veneer was stripped away and Brett Kavanaugh showed us who he really is. And on the point of temperament, I think it's important for a number of reasons that the American people really review his testimony during those hearings, these last days of this process. Because what he showed us also is two things with the way that he responded to our colleagues and approached the issue. One, he showed us that he lacks credibility. And I'll tell you why I say that, because when I was trying cases also, I recall an instruction the jury would receive at the close of the case. And the judge would give the jury instructions about how they could evaluate. It was a tool to help them evaluate the credibility of a witness. And one of the instructions was, it is relevant and significant for you to analyze the demeanor of this witness toward the proceedings. So on this point, let's recall Dr. Ford's demeanor and Judge Kavanaugh's demeanor. Dr. Ford went out of her way to be helpful and truthful. She corrected herself when she thought there was more to offer. She yielded. Would the committee like a break? If so, I'll take one. If not, I can keep going. By contrast, Judge Kavanaugh was arrogant. He was aggressive. He was accusatory, and clearly was not in control of himself. But I have to believe he was in control of his words, because as you point out, he told us he wrote his speech the night before. He said, I didn't show my staff. I just wrote these. Well, some people, we often advise people, when you're feeling hot about something, write it all out and then sleep on it. Then look at those words the next day and see if you really want to stand by them. This is a judge who's meticulous, he says, in everything he does. I believe him that he wrote those words the night before. I'm sure he slept on it. I'm sure he looked at those notes again and he decided that's what he was going with. Because it wasn't just about the heat of that moment. These are the things he really believes. That's why he said it. So let's believe him at his word. He's a partisan. And for that reason, I answer your question by saying, no, I would not select him to be on a jury.
And I think this issue of temperament, and I'm going to pose a question to my colleague from Washington, this issue of temperament is so fundamental to our system of justice in this country. Courtrooms are sometimes really emotional places, and sometimes they are angry places. And the function of the judge is to remove the emotion and the anger, to be impartial and balanced and even keeled. So for a judge on the DC Circuit Court of Appeals to engage in this kind of angry outburst, it was not spontaneous. It was not the result of some accusation in the moment. It was calculated. It was premeditated. It was written the day before. It was inexcusable and unacceptable. And I will ask my colleague from the state of Washington. Since she's not a lawyer, perhaps to her credit, if you were appearing in a courtroom with Judge Kavanaugh, wouldn't you ask that he step away from the case, that he recuse himself in light of what he has said about all Democrats, about vast classes of people, this anger that he has expressed?
The senator from Connecticut, I would just say, I know I'm not a lawyer. I was a preschool teacher. And one of the things I do know is that I wanted my students to know it's not okay to bully and that you have to take a pause and do what's right. But certainly what I would want for every one of the kids I've ever taught in preschool is to know that if anything they deeply care about an issue, or they themselves ever appear in a court, that they would feel in the United States of America, they would be given a fair shot. And win or lose, the judge presiding over them would leave them with that feeling at the end of the day. And that to me is why temperament is so important. If Americans lose that sense that no matter who they are or what their issue is or where they come from or how much money they make, in our court of law, they stand a chance to be heard even if they lose or if they win. And that's why temperament is so important to me as just a non-lawyer and someone who cares deeply about this country.
I yield back to my colleague from California, but let me just close my part of this colloquy by saying that we saw the real Brett Kavanaugh before us on that day, at that moment. And I think that my colleagues, if they review that picture, a picture's worth 1,000 words. If they apply common sense, we should not leave common sense at the door. If they put themselves in the shoes of someone appearing, seeking justice, they will vote against Brett Kavanaugh and the disrespect that he showed that brave survivor, Dr. Blasey Ford. I yield back to my colleague from California.
I thank my colleagues from Washington and from Connecticut. I agree we could find a better nominee, and I yield to the senator from the great state of Virginia.
The senator for Virginia.
Mr. President, I also rise to speak on the nomination of Judge Brett Kavanaugh to the Supreme Court. When he was nominated to fill the vacancy occasioned by the retirement of Justice Kennedy, I immediately began to read all I could about his record. I reviewed his judicial opinions, law review articles, speeches, and I reviewed, such as they were made available, documents produced from his time working with the Bush administration and his work with Special Prosecutor Ken Starr. Following the review, I met with him to ask him serious questions about his record. I then watched his Judiciary Committee hearing with interest. After that hearing, based on all I had seen and read, I announced my opposition to his nomination for two reasons. First, the nation needs a justice with the backbone to stand up as an independent check against both the president and Congress. And that's why our nation gives judges life tenure, so they can render independent rulings without fear of losing their jobs. In a whole series of writings, speeches, and rulings over the course of many years, both as a lawyer and as a judge, Judge Kavanaugh has embraced an unusual deference to executive power. I think this is one of the reasons that the president nominated him, and I don't have confidence that Judge Kavanaugh will hold the president accountable to the law. Second, Judge Kavanaugh's writings as a Bush administration lawyer, at least those the majority has allowed us to see, demonstrate his personal view that settled law is only settled until 5 justices decide to do something different. This is true as a matter of realpolitik, but I'm left with serious questions about what other areas of settled law might be unsettled should he ascend to the court. I can understand how my colleagues might reach different conclusions on the two issues that led me to oppose this nominee. But since I announced my position, 2 additional issues of great importance have arisen. The first is how the Senate, as an institution charged with leadership, will respond to the real and pervasive problem of sexual assault. And the second issue is how blatantly partisan we would want the Supreme Court to be. Christine Blasey Ford has come forward alleging that Judge Kavanaugh sexually assaulted her in high school. And Deborah Ramirez has also come forward to allege that he sexually humiliated her at a party during his time at Yale. Mr. President, the two allegations by two people who do not know each other about instances that happen at different times in different places have striking similarities. Both Ford and Ramirez allege that Kavanaugh, under the influence of alcohol and in the presence of other people, assaulted or sexually humiliated them while others stood by laughing. In both allegations, the sexual abuse of a woman was treated as some form of entertainment for other persons. People who have suffered from sexual assault or harassment are watching to see how the Senate responds to these serious charges. And what do they see? A hearing where Dr. Ford described her experience calmly, credibly, and candidly, while Judge Kavanaugh attacked her claims, as well as those of Ms. Ramirez, as nothing more than a partisan political conspiracy. A narrowly limited 5-day investigation by the FBI, who under orders from the White House contacted a handful of witnesses, while dozens of witnesses proffered by Dr. Ford and Ms. Ramirez were ignored. A single copy of the FBI investigation notes made available to senators to read, provided that its meager contents not be shared with the press or public. Even that minimal investigation raises serious concerns about these claims and Judge Kavanaugh's general truthfulness. But by moving forward to a vote anyway, the unmistakable message to survivors is the Senate does not take allegations of sexual assault seriously. More than 150 survivors of sexual abuse from Virginia have reached out to me to share their personal stories and ask that the Senate show we care about survivors. Some of these people are women I have known for decades who had never shared their stories with me. A woman from Alexandria wrote, "As a citizen, veteran, assistant professor, mother, grandmother, wife, and sexual assault victim at age 17 in 1968, I want to thank Dr. Ford for her testimony. I have never told anyone of the sexual attack, and I am 68 years old." A woman from Sterling, "I want my future daughters to grow up in a country where sexual assault and abuse is taken seriously by every official and legal professional in the United States." A man from Chesapeake, "As a male sexual assault victim, I understand how difficult it is to come forward. I strongly and respectfully urge you to attempt to sympathize with those of us who have been abused." A survivor from Radford, expressing dissatisfaction with the minimal investigation. "It makes me feel like if my attacker weren't nominated for the Supreme Court, that I wouldn't be taken seriously either." A woman from Williamsburg, "Dr. Ford has agreed to full investigations into her experiences, but our leaders are failing her and every American citizen. I watch this unfold with anticipation, hoping that my representatives will listen to us." An immigrant from Henrico, "When my family immigrated, an American couple who had helped sponsor our family became my temporary legal guardians. My sponsor mother was wonderful, but did not know that her husband repeatedly molested and raped me. It started at the age of 5 until I was returned to my family at age 9, the age of my older daughter currently." What are these survivors asking? First, that a real investigation into the charges be conducted, that the dozens of witnesses proffered by Ms. Ramirez and Dr. Ford not be ignored. And finally, that the Senate not confirm to the Supreme Court a person with a question mark by his name. To confirm Judge Kavanaugh under these circumstances would send a powerful message that the Senate, and now possibly the Supreme Court, is a hostile environment for survivors of sexual assault. The second issue raised by these allegations is how partisan we want the court to be. A person accused of any offense, especially sexual assault, is entitled to defend himself. And it would be natural to be emotional and even angry in such a defense if one felt falsely accused. But Judge Kavanaugh went far beyond that. He claimed that the allegations of Dr. Ford and Ms. Ramirez were part of a political conspiracy connected to the Democratic Party, outside activists, and the Clintons. The performance was insulting, and the conspiracy charge was a complete fabrication. There is no evidence to suggest that politics created Dr. Ford's account of being attacked at a party, her history of seeking counseling years before the nomination, the notes from her therapist, her willingness to take a polygraph, the results of that polygraph, the extensive corroboration of her story of alcohol-fueled house parties in the DC suburbs in 1982, or the admitted exploits of the alleged co-assailant Mark Judge. There is no evidence to suggest that politics created Ms. Ramirez's account of being sexually humiliated at Yale. Indeed, if the FBI had been willing to interview witnesses who are now speaking publicly, there is ample evidence corroborating the account. So when a nominee who in the past advocated slash and burn partisan tactics as part of the Starr investigation reveals that he still harbors partisan resentment and attempts to shrug off serious claims of sexual assault as a political conspiracy connected to, quote, outside left-wing groups or the Clintons, he reveals a temperament that would be very dangerous if added to the Supreme Court. That is why retired Justice John Paul Stevens has now come up urging a no vote on this nomination. The good news, Mr. President, is that there's a solution to this. There is a solution. We need not settle for a nominee burdened by questions regarding sexual assault allegations or excessive partisanship. There are numerous jurists who could meet the standards of a Republican president and a Republican Senate majority who do not have these issues. Why approve a nominee whose approval would send a hostile message to sexual assault survivors? Why approve a nominee whose nomination and approval would send a message of concern for those who don't share his political views? We can find a nominee who will not cause sexual assault survivors, litigants, or lawyers to fear how they will be treated by the nation's highest court. For the good of the Senate and for the good of the court, I urge my colleagues to vote no on the Kavanaugh nomination, and I ask the president to send up a nominee who will not hurt the reputation of either institution. And with that, Mr. President, I yield the floor.
The senator for Maine.
Thank you, Mr. President.
Senator Collins, please vote no. I am a voter from Maine.
The senator will suspend. The sergeant at arms will suspend until the sergeant at arms will restore order in the gallery. Sergeant.
This is an NBC News special report. Here's Chuck Todd.
Well, good day from Washington. We are coming on the air on what's, of course, has been a very busy news day to take you to the floor of the United States Senate, where we're about to hear from Senator Susan Collins,
As a reminder,
who's about to make a major announcement on how she intends to vote in tomorrow's final confirmation vote for Supreme Court nominee Brett Kavanaugh. We've already seen plenty of dramatic turns today as the Senate narrowly voted to close off debate and advance Kavanaugh's nomination for this vote. Collins was a yes on ending the debate this morning, which was sort of a test vote. But that doesn't necessarily mean she will vote yes tomorrow during the final vote, but we're about to find out from her. Collins is one of 4 senators who were considered question marks going into today. She is speaking now. Let's take a listen.
Of the solemn nature and the importance of the occasion. But today, we have come to the conclusion of a confirmation process that has become so dysfunctional, it looks more like a caricature of a gutter-level political campaign than a solemn occasion. The president nominated Brett Kavanaugh on July 9th. Within moments of that announcement, special interest groups raced to be the first to oppose him, including one organization that didn't even bother to fill in the judge's name on its pre-written press release. They simply wrote that they opposed Donald Trump's nomination of XX to the Supreme Court of the United States. A number of senators joined the race to announce their opposition, but they were beaten to the punch by one of our colleagues who actually announced opposition before the nominee's identity was even known. Since that time, we have seen special interest groups whip their followers into a frenzy by spreading misrepresentations and outright falsehoods about Judge Kavanaugh's judicial record. Over-the-top rhetoric and distortions of his record and testimony at his first hearing produced short-lived headlines, which, although debunked hours later, continued to live on and be spread through social media. Interest groups have also spent an unprecedented amount of dark money opposing this nomination. Our Supreme Court confirmation process has been in steady decline for more than 30 years. One can only hope that the Kavanaugh nomination is where the process has finally hit rock bottom. Against this backdrop, it is up to each individual senator to decide what the Constitution's advice and consent duty means. Informed by Alexander Hamilton's Federalist 76, I have interpreted this to mean that the president has broad discretion to consider a nominee's philosophy, whereas my duty as a senator is to focus on the nominee's qualifications as long as that nominee's philosophy is within the mainstream of judicial thought. I have always opposed litmus tests for judicial nominees with respect to their personal views or politics, but I fully expect them to be able to put aside any and all personal preferences in deciding the cases that come before them. I've never considered the president's identity or party when evaluating Supreme Court nominations. As a result, I voted in favor of Justices Roberts and Alito, who were nominated by President Bush, Justices Sotomayor and Kagan, who were nominated by President Obama, and Justice Gorsuch, who was nominated by President Trump. So I began my evaluation of Judge Kavanaugh's nomination by reviewing his 12-year record on the D.C. Circuit Court of Appeals, including his more than 300 opinions and his many speeches and law review articles. 19 attorneys, including lawyers from the nonpartisan Congressional Research Service, briefed me many times each week and assisted me in evaluating the judge's extensive record. I met with Judge Kavanaugh for more than 2 hours in my office. I listened carefully to the testimony at the committee hearings. I spoke with people who knew him personally, such as Condoleezza Rice and many others. And I talked with Judge Kavanaugh a second time by phone for another hour to ask him very specific additional questions. I also have met with thousands of my constituents, both advocates and many opponents, regarding Judge Kavanaugh. One concern that I frequently heard was that the judge would be likely to eliminate the Affordable Care Act's vital protections for people with pre-existing conditions. I disagree with this contention. In a dissent in Seven Sky v. Holder, Judge Kavanaugh rejected a challenge to the ACA on narrow procedural grounds, preserving the law in full. Many experts have said that his dissent informed Justice Roberts' opinion upholding the ACA at the Supreme Court. Furthermore, Judge Kavanaugh's approach toward the doctrine of severability is narrow. When a part of a statute is challenged on constitutional grounds, he has argued for severing the invalid clause as surgically as possible while allowing the overall law to remain intact. This was his approach in his dissent in a case that involved a challenge to the structure of the Consumer Financial Protection Bureau. In his dissent, Judge Kavanaugh argued for, quote, severing any problematic portions while leaving the remainder intact, end quote. Given the current challenges to the ACA, proponents, including myself, of protections for people with pre-existing conditions should want a justice who would take just this kind of approach. Another assertion that I've heard often is that Judge Kavanaugh cannot be trusted if a case involving alleged wrongdoing by the president were to come before the court. The basis for this argument seems to be twofold. First, Judge Kavanaugh has written that he believes that Congress should enact legislation to protect presidents from criminal prosecution or civil liability while in office. Mr. President, I believe opponents miss the mark on this issue. The fact that Judge Kavanaugh offered this legislative proposal suggests that he believes that the president does not have such protection currently. Second, there are some who argue that given the current special counsel investigation, President Trump should not even be allowed to nominate a justice. That argument ignores our recent history. President Clinton in 1993 nominated Justice Ginsburg after the Whitewater investigation was already underway, and she was confirmed 96-3. The next year, just 3 months after independent counsel Robert Fisk was named to lead the Whitewater investigation, President Clinton nominated Justice Breyer. He was confirmed 87-9. Supreme Court justices have not hesitated to rule against the presidents who have nominated them. Perhaps most notably in the United States versus Nixon, 3 Nixon appointees who heard the case joined the unanimous opinion against him. Judge Kavanaugh has been unequivocal in his belief that no president is above the law. He has stated that Marbury versus Madison, Youngstown Steel versus Sawyer, and the United States versus Nixon are 3 of the 4 greatest Supreme Court cases in history. What do they have in common? Each of them is a case where Congress served as a check on presidential power. And I would note that the 4th case that Judge Kavanaugh has pointed to as the greatest in history was Brown versus the Board of Education. One Kavanaugh decision illustrates the point about the check on presidential power directly. He wrote the opinion in Hamdan versus the United States, a case that challenges the Bush administration's military commission prosecution of an associate of Osama bin Laden. This conviction was very important to the Bush administration, but Judge Kavanaugh, who had been appointed to the DC Circuit by President Bush and had worked in President Bush's White House, ruled that the conviction was unlawful. As he explained during the hearing, quote, We don't make decisions based on who people are or their policy preferences or the moment. We base decisions on the law, end quote. Others I've met with have expressed concerns that Justice Kennedy's retirement threatens the right of same-sex couples to marry. Yet Judge Kavanaugh described the Obergefell decision, which legalized same-gender marriages, as an important landmark precedent. He also cited Justice Kennedy's recent masterpiece cake shop opinion for the court's majority, stating that, quote, the days of treating gay and lesbian Americans or gay and lesbian couples as second-class citizens who are inferior in dignity and worth are over in the Supreme Court, end quote. Others have suggested that the judge holds extreme views on birth control. In one case, Judge Kavanaugh incurred the disfavor of both sides of the political spectrum for seeking to ensure the availability of contraceptive services for women while minimizing the involvement of employers with religious objections. Although his critics frequently overlooked this point, Judge Kavanaugh's dissent rejected arguments that the government did not have a compelling interest in facilitating access to contraception. In fact, he wrote that the Supreme Court precedent strongly suggested that there was a compelling interest in facilitating access to birth control. There has also been considerable focus on the future of abortion rights based on the concern that Judge Kavanaugh would seek to overturn Roe v. Wade. Protecting this right is important to me. To my knowledge, Judge Kavanaugh is the first Supreme Court nominee to express the view that precedent is not merely a practice and tradition, but rooted in Article 3 of our Constitution itself. He believes that precedent is not just a judicial policy, it is constitutionally dictated to pay attention and pay heed to rules of precedent. In other words, precedent isn't a goal or an aspiration. It is a constitutional tenet that has to be followed except in the most extraordinary circumstances. The judge further explained that precedent provides stability, predictability, reliance, and fairness. There are, of course, rare and extraordinary times where the Supreme Court would rightly overturn a precedent. The most famous example was when the Supreme Court in Brown versus the Board of Education overruled Plessy versus Ferguson, correcting a grievously wrong decision, to use the judge's term, allowing racial inequality. But someone who believes that the importance of precedent has been rooted in the Constitution would follow long-established precedent, except in those rare circumstances where a decision is grievously wrong or deeply inconsistent with the law. Those are Judge Kavanaugh's phrases. As the judge asserted to me, a long-established precedent is not something to be trimmed, narrowed, discarded, or overlooked. Its roots in the Constitution give the concept of stare decisis greater weight, such that the precedent can't be trimmed or narrowed simply because a judge might want to on a whim. In short, his views on honoring precedent would preclude attempts to do by stealth that which one has committed not to do overtly. noting that Roe v. Wade was decided 45 years ago and reaffirmed 19 years later in Planned Parenthood versus Casey, I asked Judge Kavanaugh whether the passage of time is relevant to following precedent. He said decisions become part of our legal framework with the passage of time, and that honoring precedent is essential to maintaining public confidence. Our discussion then turned to the right of privacy, on which the Supreme Court relied in Griswold versus Connecticut, a case that struck down a law banning the use and sale of contraceptions. Griswold established the legal foundation that led to Roe 8 years later. In describing Griswold as settled law, Judge Kavanaugh observed that it was the correct application of two famous cases from the 1920s, Meyer and Pierce, that are not seriously challenged by anyone today. Finally, in his testimony, he noted repeatedly that Roe had been upheld by Planned Parenthood versus Casey, describing it as precedent on precedent. When I asked him, would it be sufficient to overturn a long-established precedent if 5 current justices believed that it was wrongly decided? He emphatically said no. Opponents frequently cite then-candidate Donald Trump's campaign pledge to nominate only judges who would overturn Roe. The Republican platform for all presidential campaigns has included this pledge since at least 1980. During this time, Republican presidents have appointed Justices O'Connor, Souter, and Kennedy to the Supreme Court. These are the very 3 justices, Republican president-appointed justices, who authored the Casey decision which reaffirmed Roe. Furthermore, pro-choice groups vigorously opposed each of these justices' nominations. Incredibly, they even circulated buttons with the slogan, "Stop Souter or women will die." Just 2 years later, Justice Souter co-authored the Casey opinion, reaffirming a woman's right to choose. Suffice it to say, prominent advocacy organizations have been wrong. These same interest groups have speculated that Judge Kavanaugh was selected to do the bidding of conservative ideologues despite his record of judicial independence. I asked the judge point blank whether he had made any commitments or pledges to anyone at the White House, to the Federalist Society, to any outside group on how he would decide cases. He unequivocally assured me that he had not. Judge Kavanaugh has received rave reviews for his 12-year track record as a judge, including for his judicial temperament. The American Bar Association gave him its highest possible rating. Its Standing Committee on the Federal Judiciary conducted an extraordinarily thorough assessment, soliciting input from almost 500 people, including his judicial colleagues. The ABA concluded that his integrity, judicial temperament, and professional competence met the highest standards. Lisa Black, who has argued more cases before the Supreme Court than any other woman in history, testified, quote, "By any objective measure, Judge Kavanaugh is clearly qualified to serve on the Supreme Court. His opinions are invariably thoughtful and fair. Ms. Blatt, who clerked for and is an ardent admirer of Justice Ginsburg, and who is, in her own words, an unapologetic defender of a woman's right to choose, says that Judge Kavanaugh fits within the mainstream of legal thought. She also observed that Judge Kavanaugh is remarkably committed to promoting women in the legal profession. That Judge Kavanaugh is more of a centrist than some of his critics maintain is reflected in the fact that he and Chief Judge Merrick Garland voted the same way in 93% of the cases that they heard together. Indeed, Chief Judge Garland joined in more than 96% of the majority opinions authored by Judge Kavanaugh, dissenting only once. Despite all this, after weeks of reviewing Judge Kavanaugh's record and listening to 32 hours of his testimony, the Senate's advice and consent roll was thrown into a tailspin following the allegations of sexual assault by Professor Christine Blasey Ford. The confirmation process now involves evaluating whether or not Judge Kavanaugh committed sexual assault and lied about it to the Judiciary Committee. Some argue that because this is a lifetime appointment to our highest court, the public interest requires that doubts be resolved against the nominee. Others see the public interest as embodied in our long-established tradition of affording to those accused of misconduct a presumption of innocence. In cases in which the facts are unclear, they would argue that the question should be resolved in favor of the nominee. Mr. President, I understand both viewpoints. This debate is complicated further by the fact that the Senate confirmation process is not a trial. But certain fundamental legal principles about due process, the presumption of innocence, and fairness do bear on my thinking, and I cannot abandon them. In evaluating any given claim of misconduct, we will be ill-served in the long run if we abandon the presumption of innocence and fairness, tempting though it may be. We must always remember that it is when passions are most inflamed that fairness is most in jeopardy. The presumption of innocence is relevant to the advice and consent function when an accusation departs from a nominee's otherwise exemplary record. I worry that departing from this presumption could lead to a lack of public faith in the judiciary and would be hugely damaging to the confirmation process moving forward. Some of the allegations levied against Judge Kavanaugh illustrate why the presumption of innocence is so important. I am thinking in particular not of the allegations raised by Professor Ford, but of the allegation that when he was a teenager, Judge Kavanaugh drugged multiple girls and used their weakened state to facilitate gang rape. This outlandish allegation was put forth without any credible supporting evidence and simply parroted public statements of others. That such an allegation can find its way into the Supreme Court confirmation process is a stark reminder about why the presumption of innocence is so ingrained in our American consciousness. Mr. President, I listened carefully to Christine Blasey Ford's testimony before the Judiciary Committee. I found her testimony to be sincere, painful, and compelling. I believe that she is a survivor of a sexual assault and that this trauma has upended her life. Nevertheless, the 4 witnesses she named could not corroborate any of the events of that evening gathering where she says the assault occurred. None of the individuals Professor Ford says were at the party has any recollection at all of that night. Judge Kavanaugh forcefully denied the allegations under penalty of perjury. Mark Judge denied under penalty of felony that he had witnessed an assault. P.J. Smith, another person allegedly at the party, denied that he was there under penalty of felony. Professor Ford's lifelong friend, Leland Kaiser, indicated that under penalty of felony, she does not remember that party. And Ms. Kaiser went further. She indicated that not only does she not remember a night like that, but also that she does not even know Brett Kavanaugh. In addition to the lack of corroborating evidence, we also learned some facts that raise more questions. For instance, since these allegations have become public, Professor Ford testified that not a single person has contacted her to say, I was at the party that night. Furthermore, the professor testified that although she does not remember how she got home that evening, she knew that because of the distance, she would have needed a ride. Yet not a single person has come forward to say that they were the one who drove her home or were in the car with her that night. And Professor Ford also indicated that even though she left that small gathering of 6 or so people abruptly and without saying goodbye and distraught, none of them called her the next day or ever to ask why she left. Is she okay? Not even her closest friend, Ms. Kaiser. Mr. President, the Constitution does not provide guidance on how we are supposed to evaluate these competing claims. It leaves that decision up to each senator. This is not a criminal trial, and I do not believe that the claims such as these need to be proved beyond a reasonable doubt. Nevertheless, fairness would dictate that the claims at least should meet a threshold of more likely than not as our standard. The facts presented do not mean that Professor Ford was not sexually assaulted that night or at some other time, but they do lead me to conclude that the allegations failed to meet the more likely than not standard. Therefore, I do not believe that these charges can fairly prevent Judge Kavanaugh from serving on the court. Let me emphasize that my approach to this question should not be misconstrued as suggesting that unwanted sexual contact of any nature is not a serious problem in this country. To the contrary, if any good at all has come from this ugly confirmation process, it has been to create an awareness that we have underestimated the pervasiveness of this terrible problem. I have been alarmed and disturbed, however, by some who have suggested that unless Judge Kavanaugh's nomination is rejected, the Senate is somehow condoning sexual assault. Nothing could be further from the truth. Every person, man or woman, who makes a charge of sexual assault deserves to be heard and treated with respect. The Me Too movement is real. It matters, it is needed, and it is long overdue. We know that rape and sexual assault are less likely to be reported to the police than other forms of assault. On average, an estimated 211,000 rapes and sexual assaults go unreported every year. We must listen to survivors, and every day we must seek to stop the criminal behavior that has hurt so many. We owe this to ourselves, our children, and generations to come. Since the hearing, I have listened to many survivors of sexual assault. Many were total strangers who told me their heart-wrenching stories for the first time in their lives. Some were friends that I had known for decades, yet with the exception of one woman who had confided in me years ago, I had no idea that they had been the victims of sexual attacks. I am grateful for their courage and their willingness to come forward. And I hope that in heightening public awareness, they have also lightened the burden that they have been quietly bearing for so many years. To them, I pledge to do all that I can to ensure that their daughters and granddaughters never share their experiences. Over the past few weeks, I have been emphatic that the Senate has an obligation to investigate and evaluate the serious allegations of sexual assault. I called for and supported the additional hearing to hear from both Professor Ford and Judge Kavanaugh. I also pushed for and supported the FBI's supplemental background investigation. This was the right thing to do. Christine Ford never sought the spotlight. She indicated that she was terrified to appear before the Senate Judiciary Committee, and she has shunned attention since then. She seemed completely unaware of Chairman Grassley's offer to allow her to testify confidentially in California. Watching her, Mr. President, I could not help but feel that some people who wanted to engineer the defeat of this nomination cared little, if at all, for her well-being. Professor Ford testified that a very limited number of people had access to her letter. Yet that letter found its way into the public domain. She testified that she never gave permission for that very private letter to be released. And yet, here we are. We are in the middle of a fight that she never sought, arguing about claims that she wanted to raise confidentially. Now, one theory I've heard espoused repeatedly is that our colleague, Senator Feinstein, leaked Professor Ford's letter at the 11th hour to derail this process. I want to state this very clearly. I know Senator Dianne Feinstein extremely well, and I believe that she would never do that. I knew that to be the case before she even stated it at the hearing. She is a person of integrity, and I stand by her. I have also heard some argue that the chairman of the committee somehow treated Professor Ford unfairly. Nothing could be further from the truth. Chairman Grassley, along with his excellent staff, treated Professor Ford with compassion and respect throughout the entire process. And that is the way the senator from Iowa has conducted himself throughout a lifetime dedicated to public service. But the fact remains, Mr. President, someone leaked this letter against Professor Ford's express wishes. I suspect, regrettably, that we will never know for certain who did it. To that leaker, who I hope is listening now, let me say that what you did was unconscionable. You have taken a survivor who was not only entitled to your respect, but who also trusted you to protect her. And you have sacrificed her well-being in a misguided attempt to win whatever political crusade you think you are fighting. My only hope is that your callous act has turned this process into such a dysfunctional circus that it will cause the Senate and indeed all Americans to reconsider how we evaluate Supreme Court nominees. If that happens, then the appalling lack of compassion you afforded Professor Ford will at least have some unintended positive consequences. Mr. President, the politically charged atmosphere surrounding this nomination has reached a fever pitch even before these allegations were known, and it has been challenging even then to separate fact from fiction. We live in a time of such great disunity as the bitter fight over this nomination, both in the Senate and among the public, clearly demonstrates. It is not merely a case of differing groups having different opinions. It is a case of people bearing extreme ill will toward those who disagree with them. In our intense focus on our differences, we have forgotten the common values that bind us together as Americans. When some of our best minds are seeking to develop even more sophisticated algorithms designed to link us to websites that only reinforce and cater to our views, we can only expect our differences to intensify. This would have alarmed the drafters of our Constitution, who were acutely aware that different values and interests could prevent Americans from becoming and remaining a single people. Indeed, of the 6 objectives they invoked in the preamble to the Constitution, the one that they put first was the formation of a more perfect union. Their vision of a more perfect union does not exist today. And if anything, we appear to be moving farther away from it. It is particularly worrisome that the Supreme Court, the institution that most Americans see as the principal guardian of our shared constitutional heritage, is viewed as part of the problem through a political lens. Mr. President, we've heard a lot of charges and countercharges about Judge Kavanaugh. But as those who have known him best have attested, he has been an exemplary public servant, judge, teacher, coach, husband, and father. Despite the turbulent, bitter fights surrounding his nomination, my fervent hope is that Brett Kavanaugh will work to lessen the divisions in the Supreme Court so that we have far fewer 5-4 decisions, and so that public confidence in our judiciary and our highest court is restored. Mr. President, I will vote to confirm Judge Kavanaugh. Thank you, Mr. President.
A 43-minute speech by the Maine Republican senator there, Susan Collins. In some ways, it was almost a prebuttal, explaining her case of why she's voting for him, explaining that she does believe Dr. Ford, explaining, perhaps trying to respond to every question that is likely to come at her from people who disagree with her decision on this. I'm joined now by my colleagues, Andrea Mitchell and Hallie Jackson, who are listening along. And Andrea,